Hello, we're glad you're joining us today. My name's Dan Nahum and I'm an economist with the Centre for Future Work. We're a Labour Economics Institute attached to the Australia Institute. And we're now running a webinar series, roughly one webinar a month, speaking with eminent voices in the world of labour economics and law. I'm joining you from Ngunnawal country here, Canberra. I pay my respects to elders past, present and emerging, as well as to any Aboriginal and Torres Strait Islander people who might be joining us here today. Casual employment has dominated Australia's labour market recovery from COVID. And the right of employers to hire staff on a casual basis in almost any role they choose, including jobs that appear to have permanent characteristics, seems to have been cemented by recent amendments to the Fair Work Act and by the High Court's recent ruling in the WorkPac versus Rossato case. The rise of casual and insecure employment arrangements in Australia is of considerable concern to us here at the Centre for Future Work, and we frequently publish analysis on it. For example, our director, Dr. Jim Stanford, recently published the report, Shock Troops of the Pandemic, Casual and Insecure Work in COVID and Beyond. And I gather that Jim will provide a link to that in the chat box below. Additionally, the Australian Council of Trade Unions are running an ongoing and high-profile campaign around insecure work, making the case that insecure work is not just bad for individual workers, but it's also bad news macroeconomically and socially, including in terms of work health and safety and public health. To explore the factors underlying the rise of insecure work in Australia further and consider where to from here, we're lucky and honoured today to be joined by one of Australia's foremost experts in labour law. Professor Andrew Stewart is the John Bray Professor of Law at the University of Adelaide, an Oxford Law graduate. He is a Fellow of the Australian Academy of Law, an editor of the Australian Journal of Labour Law, and a co-director of the Adelaide Law School's research group on work and employment regulation. His previous positions include being Dean of Law at Flinders University, convener of the Committee of Australian Law Deans, and President of the Australasian Law Teachers Association. He has been the President of the Australian Labour Law Association since 2009. He has provided expert advice to the International Labour Organisation, to federal and state governments in Australia, and to a wide range of other organisations. Andrew is one of Australia's leading experts in workplace relations and employment law, and he is, of course, widely published. At the Centre for Future Work, we've been lucky enough to enjoy Andrew's expert advice and collaboration, including joining with our director, Dr. Jim Stanford, and Tess Hardy to co-edit the book, The Wages Crisis in Australia, What It Is and What to Do About It. He has also co-edited with Anthony Forsyth, an associate of our centre, a recent special issue of the Australian Journal of Labour Law on the impacts of COVID on labour market policy and regulation. Andrew will first of all present to us, and then we'll have time for an audience Q&A. You can place your questions in the Q&A box in Zoom, and there's a chat box as well. Please keep things civil there, otherwise we'll need to boot you out. This has rarely been necessary. So without further ado, thank you so much for joining us, Andrew.
All right, thanks so much, Dan. Thank you, Jim. Thank you to everyone at the Centre for giving me the opportunity to talk to you today. As Dan said, I'm going to talk about where we go from here with casual employment, but it's a topic that really you cannot work out where the destination might be without understanding where we are right now and how we got here. And it really is a peculiar and complex legal story that has been complicated further by both the legislation passed this year and by a seemingly important, but actually not so much, decision handed down by the High Court in the Rossato case. Although what I'm going to say about that decision, which was handed down in August, is that if it does have real practical significance, that significance is still yet to come with some further decisions. I'll at least touch on that. But at the end of the presentation, I'm going to do my very best, unusually for me, to stick to time and actually get through everything quickly, something my students know I'm appallingly bad at, and leave a little bit of time to talk about where I think we might be heading and put forward some imperfect, unlikely to be supported, but I think practical ideas for how we get from the current situation to a more satisfactory approach to the casualisation of the labour market. The one thing I don't think that any of us can doubt is that casualisation is a problem, and it's a problem for the kind of reasons that the Centre has been articulating over the last few years in a number of publications, including by Jim and Dan. We've seen it be a major contributor to the spread of the COVID pandemic. We already know this with the first Victorian outbreak, but I don't doubt that when the full story is told about the New South Wales Delta outbreak that has then spread so tragically into Victoria, that we're going to find that the role of casual work, insecure employment workers unable to take leave or feel that they can take leave from their jobs and contributing significantly to the spread of the disease is going to prove to be as significant factor as we know it already was in the 2020 Victorian outbreak. But for the moment, let me back up and just get some legal stuff out of the way, and I'm going to use some slides here so that you can follow some of the legal points that I'm making. Okay, so hopefully that's come up okay on your screen. So, casual employment, what do we know about it? Well, we know that about 1 in 4 of all employees in Australia work as casuals. That percentage has gone up and down a little bit, but it stayed pretty steady for over the last two decades within at least some parameters, say between 22, 23, 27, 28%. We contrast casual employment typically with permanent employment, though that in itself is a bit of a misnomer because many people employed in so-called permanent jobs have about as much real job security as many casuals, certainly many long-term casuals. We know that casuals can be full-time or part-time casual employment more prevalent, but full-time casual employment very much being a feature of the labour market. We know that legally, the deal with casual employment is you get, or you're meant to get, a 25% wage premium in return for not having any rights to annual leave, paid sick leave or paid carers leave, not having any rights to minimum notice of termination or redundancy pay. But what I think a lot of people aren't aware of, this has been a significant legal development over the last 3 decades, is that casuals are entitled to a very wide range of other legal benefits. They qualify for unpaid parental leave in just the same way as permanent employees do. They get long service leave if they stay in their job for long enough. Every state and territory law now reflects that principle. If they earn at least $450 a month, then they are entitled to get superannuation guarantee contributions for their employer. And the Morrison government has promised to remove that limit from July 2022, so that if that happens, superannuation will become a more prevalent entitlement for casuals. And they're also entitled, again, if they last in their jobs for long enough, and as we'll see in a minute, many of them do, they're also entitled to unfair dismissal protection as well. The really tricky issue, sorry, I'm just making sure that I can advance my slides here, there we go. The really tricky issue with casual employment though, and this has been a long-term legal problem, is the lack of a single accepted definition of casual employment, or more especially, a tension that has emerged between the general legal understanding of what a casual is. That is, the idea that in its true sense, casual employment is informal, uncertain and irregular. So think about somebody who's employed to work on the Royal Show, somebody who's employed to work for the life of a sporting event, somebody who's occasionally used to fill in at a particular workplace, somebody who's who might work at a pub every now and again when the demand is sufficient. That is casual employment in the general legal sense. But what we've also had is awards in particular, and in turn many enterprise agreements, coming to define a casual least until recently, as I'll explain, as anybody, as an employee who's been engaged and paid as a casual. That award definition has, in effect, given employers absolute unfettered freedom to treat someone as a casual as long as they tell the worker they're a casual and pay them as a casual. And that's how we've ended up. That's the legal explanation. The social and economic explanations are much broader and much more complex. But the legal explanation for how we end up with permanent casuals, and there are a lot of them, we're talking well over 1 million Australian workers at any one point in time are in this category. Workers whose jobs are not casual at all. They're doing ongoing work. There may be uncertainty about how long they'll last in their job, but no more uncertainty than a permanent employee would have. There is nothing irregular about their work. They're doing, in many cases, the same hours of work every week. And the fact that the average casual lasts in their job for more than a year gives us a sense just how many of these kinds of casual workers there are. So, in theory, this has been a huge legal problem for many, many years. In practice, not so much, partly because very few casuals or unions representing casuals or lawyers representing casuals have ever challenged this state of events. And partly too because, and I'll come back to this really important point later, many of the casuals who are affected by this are either happy with that state of affairs or at least do not feel they can afford to challenge it. But in any event, it was really only until a couple of recent high-profile cases were brought against the labour hire provider WorkPac that we saw the tension between the general understanding of the casual as being somebody doing a temporary, irregular, uncertain job and the common practice of hiring people as casuals simply on the basis they've been told that they're casuals being explored. So in these two cases, mine workers who were doing full-time jobs, working set rosters which had been arranged months or years in advance, were found by the federal court not to be casuals in the general legal sense. The key point here was that the Fair Work Act at the time of these cases did not have a definition of casual employment. The federal court filled the gap by saying, you're a casual if your job has the requisite, love this phrase, essence of casualness. And the essence of casualness is the absence of a firm advance commitment from the employer as to how long the work will last or as to when the work will occur. So in both these cases, the federal court said, even though the contracts that they had signed made it clear they were only working for the duration of certain assignments, the practical reality was that it was absolutely clear that they were doing ongoing jobs. That made them casuals for the purpose of the Fair Work Act, which meant that they did not fall within the exceptions to entitlements like annual leave. So at the end of their jobs, they were able to make claims for unpaid annual leave. In the Rossato case, WorkPac tried to argue, well, okay, even if we misclassified Mr. Rossato as a casual, even if we now owe him all this money for unpaid annual leave, we've been paying him a casual loading. We should be able to either set that casual loading off against the money we now owe him for annual leave, or if we can't do that, separate legal argument, we should be able to sue him to get the casual loading back on the basis that it's been paid to him either by mistake or on a basis which doesn't legally exist. Those arguments are rejected for technical reasons I'm not proposing to get into, but nothing surprising about the finding in these cases. So these cases did not break any great legal ground whatsoever. All they did was just confirm that employers who were treating and paying someone as a casual on the basis of how they were labelled by the employer would be taking a significant risk of being found to have misclassified them if their jobs were not truly classified. However, the fact this was brought in the mining industry with union support and as part of a big campaign against insecure labour hire employment in that industry, persuaded employers to take the risk seriously, where for years and years and years it was something that, while people like myself might have been talking about and writing about, hadn't translated into genuine concern. So now these decisions prompted employer groups to say, let's just total up what employees could be, misclassified casuals could be entitled to if they lodged a claim. Hang on a minute, are we sure those figures are right? Because they seem to have 9 or 10 figures to them. Yes, they are. Billions of dollars worth of unpaid entitlements, not an exaggeration. That's a genuine estimate of what potentially misclassified casuals could claim. So in the end, we get 2 separate reactions to the WorkPac cases. The first one comes in the form of the legislation introduced by the Morrison government, originally as part of the so-called Omnibus Bill. This is meant to be a wide-ranging bill introducing reforms which have been discussed with working groups established back in the heady days of 2020, when apparently cooperation was still a thing, or at least was briefly a thing in terms of labour regulation. The bill ultimately, as I'm sure everyone listening to this webinar will be aware, the bill ultimately was gutted by the government itself, including of sections of the bill which had the full support of Parliament. But what was left was passed as the Fair Work Amendment Act, dealing solely with the issue of casual employment. So there were 4 main elements to the legislation. I'm very quickly going to go through each of them. The first of them was a new and retrospective definition of casual employment added to the Fair Work Act, saying that someone is a casual if they accept the offer of employment on the basis that the employer makes no firm advance commitment to continuing an indefinite work according to an agreed pattern of work. Now, that language is straight out of the WorkPac cases. So on the face of it, and the government claimed as much, it's departing from the idea of you're a casual if the employer says you are. You're a casual only if your employer is not making a firm advance commitment. However, the only factors that can be considered in determining whether someone falls within that new definition is whether the employer can elect to offer work which the person is free to accept or reject. Is the employee working only as required according to when the employer needs it and not otherwise? Has the employment been described as casual? Are they paid a casual loading or a specific casual rate of pay? Those are the only factors. Then we get to the really important parts of the new definition. 2 propositions. Having a regular pattern of hours is not enough to indicate an advance commitment. So the fact that you end up working set rosters, working according to a predictable pattern, is not enough to make you a casual. And it's only the original offer and acceptance of work, in other words, the contract under which you've been engaged, that matters, not any later conduct. That involved explicitly departing from the approach in the WorkPac cases, where what the court was looking at was the reality of the working relationship, not solely the original terms of the contract. The legislation is saying, look to the original terms of the contract. So does this mean that crisis averted, we now go back to where we were before those nasty WorkPac decisions? The answer is no, and really strongly no. The legislation, on the face of it, which it's in my view, not very well drafted legislation at all, but what it is clearly tailored to do is to reverse the WorkPac decisions and meet the needs, in particular, of the mining industry. More generally, it works for large, well-organised employers who are very good at putting the right words into their employment contracts, who are very good about not simultaneously telling their workers, don't worry about what the contract says, really, you're getting ongoing work. And also employers who really don't care who does the work as long as someone's prepared to sign up for it. This is not legislation drafted with smaller employers in mind, or less organised employers, or employers that want to hire workers as casuals, but can't really give them contracts that involve no ongoing commitments, because the nature of the work does require an ongoing commitment. Thinking there, for example, about a lot of casual teachers at university, let's say, if someone's being hired to work as a casual teaching in a particular subject, you do not want to give them a contract that says, okay, so we're guaranteeing you no work, we may or may not ask you to turn up, and you're free to either work or not as you see fit. That would be the contract that would fit with the definition. That's not a contract that makes any sense when you want to ensure there's a teacher there each week teaching the relevant class. What this legislation has done is solve a problem in one part of the labour market and created massive uncertainty for other employers. There are many, many employers who are now far worse off. That's even before we get to all the red tape I'm going to mention in a minute, who will now, instead of being able to rely on their award definition saying, well, you're a casual because we've engaged you as a casual, now have to go through the uncertainties of the new definition. There's a particular problem about how you characterise fixed-term employment under the new definition. We've got time later in questions, happy to come back to that, but I do want to move on and make good on my promise of leaving some time for questions. Second element of the legislation is protection that if you've misclassified a casual as an employer and they claim entitlements, you can offset any part of the loading or the relevant part of the loading you paid the employee. But you don't get off scot-free because you can still be subject to penalties for not having paid the relevant entitlements at the time they were supposed to be paid. So this is not complete protection for employers. There's a whole lot of new obligations on employers. Now, what really, really irks me about this aspect of the legislation is, for reasons I'll explain, it does almost no good for employees. It provides almost no use for employees, most casual employees in a practical sense, but it creates a huge amount of red tape for employers. So every employee has to get a practically useless statement telling them about rights that they will almost certainly not exercise on being employed. And there's also this elaborate set of rules about having to offer or consider whether to offer conversion to permanent employment, to deal with requests for permanent employment, in all cases coming with extensive obligations about giving written reasons, written statements. This is not a pro-employer piece of legislation, is the point I'm making. I'll come back to the question of, does the so-called right to have casual conversion considered or offered, does that mean anything? I'll come back to that very shortly. Commission was also required by, Fair Work Commission was required by the legislation to review award terms and complete that job by the 27th of September. They did. What essentially the Commission has done is to delete almost all existing definitions of casual, almost all casual conversion provisions in awards, and replace them with references to the legislation, thereby taking what was a relatively straightforward, well understood set of provisions and now replacing them with references to the statutory definition in particular, which we still really don't know what it means and won't know what it means until we go through some test cases. It's not to say that all award provisions on casual employment have gone. So the relatively few awards that have limitations on the use of casual employment still have them. Requirements to inform an employee that they're a casual, that still has been retained where it was part of awards. But otherwise, the contradictions between old award provisions and the new legislation largely now being removed. The other big development, of course, in the last 6 months, as I mentioned, was the WorkPac and Rossato case going to the High Court. So the High Court charges over the hill here to rescue the business community against the spectre of misclassification, and only to find that now I'm struggling to actually maintain the metaphor here and keep it working, only to find that the battlefield they were riding onto has been cleaned up. That will do. The High Court, by the time it rules on this case, is ruling on the applicability of entitlements and provisions in legislation that's now been retrospectively amended. So the decision in WorkPac, strictly speaking, is relevant only to Mr. Rossato. But for what it's worth, the High Court said that they accepted the idea expressed in the WorkPac cases that you have to look for a firm advance commitment, whether there is or isn't a firm advance commitment to offer ongoing work. But crucially, the difference they expressed and the reason for overturning the federal court's finding that Mr. Rossato was a casual, and also effectively indicating that they thought that the finding in the scheme case as well was wrong, is they said that where you've got a written contract that appears to be comprehensive, it's only the terms of that matter. It's only the terms of that contract that matter, not the reality of the relationship, unless it can be established the contract is a sham. Now, as a matter of common law, it's very hard to show that a contract is a sham. That would, say, cover a situation where I want to pay you some money, but I want to disguise the gift, so I pretend to employ you. So supposedly I'm paying you for services rendered, you're not actually working for me at all. It's just a vehicle to give you some money. That's a sham, right? These contracts are almost certainly not going to be regarded as shams. They might be contracts that conflict with the reality of how the contract is being operationalized or performed, but that is not the common law a sham. So what does this finding mean? Well, really, it just retrospectively brings the common law into line with what the legislation now says, except from an employer perspective, if they waited and hadn't pressed, if employer groups had not pressed the government to legislate at the time they did, this decision would have solved most employers' problems. And it would have done so without all of this incredibly expensive and difficult red tape, and without getting rid of award provisions that, whatever else you might say about them, were pretty clear. The High Court also said it didn't need to consider the difficult issues about set-off and restitution that I mentioned earlier, because those issues didn't arise if Mr. Rossato hadn't in fact been misclassified. So the decision itself has little direct relevance. I suspect it'll still get quoted a lot because people will just assume it's important. Its real significance, arguably, and this was my reaction on the day, every other Labor lawyer I know on the day had exactly the same reaction. What we all were focusing on was not the finding about whether Mr. Rossato was a casual, but what this might suggest about the way in which the High Court determines other issues of employment status, and in particular, distinguishing between employees and independent contractors. So there are two big cases which have been argued in the High Court. We're waiting on decisions. One, the Jamset case, which involves some owner-drivers who worked for the same lighting company for 40 years and who were found by the federal court to be employees. The other, the personnel contracting case involving an unskilled building worker who was found to have been an independent contractor, supposedly, although the federal court made it as clear as they could make it, that they thought that was completely wrong and that they were only saying that he was a contractor because they were bound by previous state court decisions to find that. So we're waiting on the High Court's ruling, but in those cases, but what the High Court seems to be signalling here, particularly in the way it referred to what had previously been regarded as the leading High Court decision on determination of employment status, the Hollis and Barbu case from 2001, what the court appears to be signalling here is when we're deciding who's an employee and who's a contractor, we're only going to look at what their contract says, not their reality of their relationship. Okay, so let me just very quickly conclude, having just given you that very quick tour through some very complex legal terrain to explain where we've got to. Where we've got to is we've still got a ton of permanent casuals and nothing that either the legislation has done or that the High Court has said is on the face of it going to make any difference. If we do think, as I said at the start, we do think that having a large number of Australian employees in legally insecure employment, even though the jobs they're doing are ongoing, if we think that's a problem, which I do, what should we do about it? But if we're going to do something about it, I think it's really important to look at to understand three features of the current labour market. One is, why do so many employers hire workers as casuals when they're doing ongoing jobs? I think, and this is a matter of observation rather than empirical reality, but I don't think it's too hard to prove, that it's actually more about the illusion of flexibility rather than cost savings. It's about a feeling that I can hire you and fire you whenever I want, even though, as I mentioned earlier, if a casual worker is employed for long enough, they have the same rights to challenge their dismissal. They have some of the same leave entitlements as permanent workers. If they're good and they're valuable, they have as much security in their job at a practical level, just not at a legal level, as permanent workers. And the cost savings, I've spoken to many employer group representatives who pleaded with their members to employ workers on a permanent part-time basis because it's cheaper than being a casual. For many workers, what does casual employment come to mean in practice? Basically a way of being paid not to take leave. At a practical level, for permanent casuals, they're getting pay rather than getting leave entitlements that they may never use. In some industries, I also think this is important too, certainly in the mining industry. The real issue here is labour hire. The fact that many labour hire agencies engage workers as casuals is actually not the main issue. The main issue is the use of labour hire to be able to employ workers on terms which undercut collectively negotiated rates of pay at if those workers were hired directly. To my mind, the issue that should be addressed as an issue of regulating labour hire, about regulating equal rates of pay, equal right to equal equality of conditions, not so much as an issue of casual employment. The main point I want to make is that casual conversion rights are not the answer. They're going to be resisted by employers, even when it would make more sense rationally for those employers to agree to permanent employment. They are going to be resisted by most workers because they will, permanent employment means taking a pay cut if they're being paid properly. Oh, and if they're not being paid properly, they're not being paid a casual loading, then their employer is certainly not thinking about casual conversion rights because they're in breach of the law already. I think a more practical solution, rather than thinking about casual conversion rights, which has been a preoccupation of the union movement for the last 2 decades, is to think about the idea of extending the concept of gaining rights over time. So this is a proposal I've put up before. I'm going to repeat it. The idea is that after 12 months, if you hit the 12-month mark, you get permanent employment automatically unless you elect otherwise. It's not the employer's decision, it's the workers. Most workers will elect to stay casual because they won't want the pay cut. But they start getting rights. They get the right to take unpaid annual leave at that point. They get the right to notice of termination on the same basis as permanent workers. Then after a further 3 years, and you could change the figures here, okay? I'm just picking them out of the air. After 3 years, they get paid annual leave, but their loading reduces, let's say to 15% or to 20% or to 10%, whatever you think is appropriate. After 5 years, you cannot be a casual any longer. You automatically become permanent and you get the other rights you would get as a permanent employment. The idea there is that you wean employees off the loading over a period of time and give them a genuine basis to accept the idea of permanent employment, and you take it out of the hands of employers to block that. That's the suggestion. Do I think that proposal is likely to win support from anybody? Almost certainly not, okay? As long as unions are fixated on the idea of casual conversion, and as long as employers are fixated on the idea of we decide who a casual is, no one's going to support this idea. Is it an ideal way to regulate casual employment if we could start over? Absolutely not. This is not just a second best, it's like a fifth best solution. But do I think it's a workable compromise to fix a broken system? Accepting that we can't start from where we are, we have to start with the reality of so many people being used to, so many businesses, so many workers being used to casual employment. Maybe, you know, every now and again, I'll put up ideas where I think the power of persuasion could see this idea taken up. I genuinely have no sense of optimism about this particular proposal, but I still think, this is where my thinking's been now for many, many years, I still think that something in this territory makes more sense than either the idea of trying to tell employers they can't have casuals or giving workers a conversion right that most of them will not exercise. All right, I've gone over time, but we've still got some time left, Dan, so over to you.
Oh, this has been a really splendid presentation. I've learnt so much, and I'm worrying less about things that I was worrying about and worrying more about things I wasn't worrying about. So you've changed my opinion about what to worry about, and I guess maybe that was your goal.